So now a super important article. Now we'll go into full concept mode. तो बिल्कुल ध्यान से सुनना. A lot of writs to be understood. Entire right has to be understood. There are a lot of questions from this in your exam. So ध्यान से सुनना और समझना. Which article are we talking about? We are talking about Article 32, which is called Right to Constitutional Remedies. The right that gives meaning to all other rights. सबसे पहले समझो आइडिया क्या है इस राइट का. So we have been given right to life, we have been given right to freedom, we have been given right against exploitation. All of this will only make sense when I am guaranteed these rights. Because remember, I told you the definition of rights? They are claims. So you are supposed to get them come what may. But what if my fundamental right is violated? What do I do in that case? How is it ensured that I will be provided remedy in case there is a violation of my fundamental right? This is precisely what Article 32 tells you. Article 32 tells you that in case your fundamental right is violated, you can directly move to Supreme Court and ensure its enforcement. Now, why is this so significant, my dear students? Because otherwise, we have a judiciary that is integrated. Remember, I told you this concept of integrated judiciary? Session Court, High Court, Supreme Court. So otherwise, how you move is you first go to Session Court, then you move to High Court, and then you go to Supreme Court. You can't directly approach Supreme Court for all other matters. But in case there is a violation of your fundamental rights, you have the right to move to Supreme Court directly. And this is a very important way of ensuring that your fundamental rights are guaranteed to you. So what does Article 32 tell me? In case my fundamental right is violated, I can move to Supreme Court directly. Also, to ensure that my fundamental rights are enforced, what the court will be doing is it will be issuing certain writs. To put it very simply, I'll be teaching you each of these writs in detail. But to put it simply, writs are nothing but orders to do something or to not do something. So to ensure that nobody is violating your fundamental right, court will issue these orders under the name of writ. Why is this so significant? Because these will be issued directly by the Supreme Court, which is the apex court in the country. And that is why Article 32 is called the heart and soul of the Indian Constitution, because without Article 32, other fundamental rights will have no meaning. Again, a very important point where you can get a question in your prelims examination. Now, for the purpose of Article 32, Constitution says that the power to issue writs for the enforcement of fundamental right will lie with Supreme Court. This is what the Constitution says. But at the same time, Constitution says that if Parliament wants to give this power to any other court, let's say High Court or let's say Session Court, then it can do so. However, Constitution is giving this right, this power only to the Supreme Court and not to any other courts. Now you'll tell me, but ma'am, I have heard that High Court can also issue writs. Yes, it can. I'll be teaching you that. But that is under Article 226, not under Article 32. So bilkul confuse mat hona. As per the Constitution of India, the right to issue writs for the enforcement of fundamental rights is only with the Supreme Court. However, the Parliament has been given this power that if you want to do that, you can give this power to any other court. And the word any is important here because Parliament by a law can actually give it to any court of the country. It can be a session court, it can be a high court as well. Often neglected point can appear in your prelims. So make sure that you're listening to me very, very carefully. Now, keep giving me a yes or a no in the chat box so that I know that you are with me. Now we are on the 7th class. Speed will definitely increase. Done with certain concepts. So I want you to give your 100% concentration here. So there is something called as concentration learning, which is the idea that if you give your 100% to what the speaker is telling you, there's more chances of you recalling it in examination. So make sure that there are no distractions around and you listen to each word that I have to say here. So yes, important, Parliament can empower any court to issue writs of all kinds. Super important. Now very, very important. Can this right that I enjoy with regards to enforcement of my fundamental right, can it ever be suspended? Yes, it can. And that is during the times of national emergency. So I'll be teaching you that there is an emergency called national emergency. In case that is imposed, president can decide that my right to move to court will be suspended. However, there are certain restrictions to it. For example, you can't do it for Article 20 and 21, which I'll be teaching you later. However, can Article 32 be suspended? If that is the question, yes, it can be. I hope that is making sense to you, everyone. Akshara says that has worked for me. So please listen to Akshara. She is right. Of all kinds include fundamental rights as well. Yes, for the writs, issuance of writs, Priyanka. ठीक है. सो कोशिश करो आज एक छोटी सी एक्सरसाइज करो मेरे साथ. लेट्स डू दिस एक्सपेरिमेंट. 2 hour एक्सपेरिमेंट करो. 1.5 hour एक्सपेरिमेंट करो. इट्स 7:30. ट्राई एंड टेल योर ब्रेन दैट फॉर द नेक्स्ट 1.5 hours आई गिव माई 100% कॉन्सेंट्रेशन टू वॉट मैम इज सेइंग. एक बार ट्राई करके देखो, ठीक है. एंड यू देन सॉल्व द क्वेश्चन बेस्ड ऑन दीज टॉपिक्स एंड यूल रियलाइज वॉट आई एम ट्राइंग टू से. Chalo. So that is the things that you need to remember. Also, as I told you, this is the right that will be protecting your fundamental rights. So, in effect, your fundamental rights get meaning because of Article 32. That is why it is called the very soul of the Constitution, the very heart of it. Dr. B.R. Ambedkar ne kaha tha. Again, very important. Supreme Court is thought to be as the defender and the guarantor of these fundamental rights. Why, my dear students? Because again, under Article 32, I can directly move to Supreme Court. I don't need to go from Session Court to High Court to Supreme Court. No need. I can directly go to Supreme Court. Very important. Now, this point I'd like you to focus a little on. Let's say there is a case, right? that I believe has some bearing on fundamental right, and therefore I take it directly to Supreme Court. Supreme Court in its observation realizes that this case has no bearing on fundamental right. Then your case cannot be admitted under Article 32. So please remember, if a particular case has no bearing on fundamental right, if it has nothing to do with fundamental rights, Article 32 will not come into picture. Article 32 comes into picture only when there is a violation of fundamental rights. Otherwise, it will not be entertained under Article 32. Super important. Then, ma'am, what is this Article 226? ध्यान से सुनना. Article 226 gives the same power to High Court. So actually, with regards to protecting your fundamental rights, Supreme Court is not the only authority. So there can be a line in your prelims and you'll get trapped. Article 32, Article 226 gives High Court concurrent jurisdiction with Supreme Court. Look at the use of the word concurrent. Why am I using the word concurrent here? Because High Court can also issue writs for the enforcement of fundamental right. Supreme Court can also issue writs for the enforcement of fundamental right. However, for Supreme Court, the article that comes into picture would be Article 32, and for High Court that comes into picture would be Article 226. Now I'll give you a very important point here जो आपको बहुत ध्यान से सुनना है. Article 226 का use करके, if you approach High Court and tell the High Court that my fundamental right has been violated, High Court may or may not accept your petition. High Court can refuse to accept your petition, but Supreme Court cannot. It sounds incorrect कि Supreme Court is appearing to be less powerful than High Court, but yes, it is. So what does this effectively mean is, if I'm using my Article 32 and knock going to Supreme Court cannot refuse my case to be admitted. However, if it is Article 226 that I have used, High Court can refuse it. Ma'am, ऐसा क्यों किया? Because Supreme Court would be my last resort. In case High Court refuse, there's somebody who will not refuse. So what I'm trying to tell you here is, Article 226 में, the issuance of writs for the High Court is actually discretionary, whereas Supreme Court cannot use discretion here. Now, somebody is saying, ma'am, why would we ever go to High Court? Because it is easier. High Court would be in your state. For approaching Supreme Court, you will have to go to Delhi. So proximity, less burdensome procedure, more familiarity are the reasons why you would want to go to High Court first. In fact, my dear students, technically, constitutionally speaking, you have all the right to approach Supreme Court. If your fundamental rights are violated, you have all the right to approach Supreme Court. However, Supreme Court itself says that a petitioner should first try to move to High Court and then come to Supreme Court. Why do you think Supreme Court itself will say that? Supreme Court time and again has mentioned that the priority for the citizen should be first to go to High Court and then they should come to Supreme Court. However, this is not something that can be forced on you. You have all the rights to approach Supreme Court in case your fundamental rights is violated. However, why this is done is because high courts are more in number. So it will be easier for the high courts to take up issues. Whereas Supreme Court is already burdened. Less staff, only one. So that is why Supreme Court time and again says this, that you should first move to High Court and then as a last resort should anybody be coming to Supreme Court. Whatever I've mentioned here is super important. Make sure that you know it. I'll put it again for you. I'll make it revise. ध्यान से सुन लेना. If my fundamental right is violated, I can approach Supreme Court using Article 32 and I can go to Supreme Court directly without following hierarchy. Since this defends, since this guarantees me that my fundamental right will be protected, it is called as the heart and soul of the Indian Constitution. I repeat, if a case does not involve any bearing on fundamental right, then it will not be admitted under Article 32. Does Supreme Court will evaluate and then answer? Yes, it can. If Supreme Court feels that the case has no bearing on fundamental rights, then it might refuse to admit it. However, if there is a bearing, then Supreme Court has no prerogative to say no. However, High Court, if you are approaching, you will approach under Article 226. That is why it is called concurrent jurisdiction of High Court. Concurrent meaning parallel. Supreme Court also has it and High Court also has it. Finally, if I am approaching the court under Article 226 going to High Court, I may or may not be, my petition may or may not be accepted. But if I am going to Supreme Court, it is not the discretion of the Supreme Court. As I told you, Supreme Court itself says that a petitioner should first try to go to High Court and then move to Supreme Court. So when I talk about the writ jurisdiction of Supreme Court and High Court, there can be a question on this. ध्यान से सुनना. When I talk about Supreme Court under Article 32, Article 32 के तहत, when a writ is being issued by Supreme Court, then it can only be issued for the enforcement of fundamental rights, not for legal rights. Whereas High Court under Article 226 can issue writs for the enforcement of legal rights as well. Therefore, we often say that the writ jurisdiction of High Court is wider than that of Supreme Court. Sound सही नहीं करता, पर बिल्कुल सही है. Understand the logic. So writs, which are orders, can be issued by High Court for both legal rights as well as fundamental rights. Whereas Supreme Court under Article 32 can only use it for the enforcement of fundamental rights because Article 32 is specific to fundamental rights. So what would be the conclusion? The writ jurisdiction of High Court is wider than that of Supreme Court. Very important. Supreme Court can issue it for the entire country. So the jurisdiction is wider. High Court can only do it in the territory. So it is smaller. Article 32 is itself a fundamental right, I told you. So Supreme Court cannot refuse. It cannot say no. However, High Court can refuse because Article 226 is not a fundamental right. Are we here, everyone? Is it making sense to you? So that brings me to the question. How are fundamental rights different from legal rights and how is this different from constitutional right? So this is your homework number 1 for today. Abhiru, please note it down. By the way, we have to discuss yesterday's homeworks as well. What is the difference between constitutional right, statutory right, and fundamental right? So how are fundamental rights different from legal rights and how are legal rights different from constitutional rights? You'll let me know. Now, one by one, we'll go on into each of these writs. Last year also there was a question on writs. हर साल question आता है. Set topics हैं. If you prepare, you are going to get your answer is correct. No worries. So ध्यान से सुनना, 100% concentration here. Try to memorize. The first writ that we are talking about is habeas corpus. The literal translation of which is to have the body of. Now, what does this mean? Let's understand with an example. If somebody is detained unlawfully, so we have already heard of arrest and detention. So if somebody has been kept in custody and this custody is illegal in nature, let's say 24 hours ho gaye and you have not been produced in the front of the magistrate. This is one example of custody being illegal. So the court will issue a writ and will say that you have the body of or you bring the body of. So if some person has been detained unlawfully, the court will order you that you bring that person in front of me so that I can see whether the detention is lawful or not. That is why it is called to have the body of. Are we here, my dear students? I have also given you some questions here. तो ये भी आपको सॉल्व करना है. Make sure that you're listening to me very, very carefully. Now, why it is called as the bulwark of individual liberty against arbitrary detention? Because in a way it is protecting my liberty by ensuring that I'm not kept in detention arbitrarily. How will court ensure that? By issuing this writ of habeas corpus and saying that you bring the body of the person who has been kept in detention. However, it cannot be issued if the detention is lawful, meaning if you have detained somebody, presented that person in the front of the magistrate, and the magistrate has allowed for the detention, then habeas corpus cannot be issued. Or let's say the detention is under preventive detention, मैंने आपको पढ़ा है, then also habeas corpus cannot be issued. अब ध्यान से सुनना. In case it is a case of contempt of legislature or contempt of court, I've already explained contempt of court to you. How many of you remember? Ha. So in that case also, habeas corpus cannot be issued. Finally, if the court has ordered that detention, let's say court ने बोला कि आपको 10 साल की सजा हो गई and you have been put behind bars, you can't apply for you can't apply for habeas corpus then कि I have the right to be free. In that case, you have been detained lawfully. Your detention is ordered by a competent court. Finally, if the detention is outside the jurisdiction of the court, meaning the high court, let's say you move to high court for it and it is outside the jurisdiction of the high court, then habeas corpus cannot be issued. So again, a very important question for your prelims. Can this writ be issued against both public and private individuals? Yes. Very important, often asked question. Habeas corpus can be issued against public authorities also and can be issued against private individuals as well. I repeat, the writ is called habeas corpus. Literal translation is to have the body of. The idea is if somebody has been detained unlawfully, then the Supreme Court will say that you bring the body of so that we can see that whether the detention is lawful or not. If it has been found out that the detention is unlawful, has violative of law, then you will be released on that day itself to ensure that your individual liberty is protected. However, if the detention is lawful, if the detention is for contempt of court, or it has been given by a competent court authority, or it is outside the jurisdiction of the court, then habeas corpus cannot be issued. Are we on the same page, my dear students? Is it making sense to you? Any questions so far? Can it be issued against public officials? Yes. Can it be issued against private individuals? Yes. दोनों के against आ सकती है, कोई problem नहीं है. So it can be police, it can be government, it can be private entity, etc. etc. Easy to understand? No problem so far? Great. सबका ध्यान यही होगा. I remind you, we are doing the 2 hours concentration challenge. तो वो on है. Second is mandamus. The literal translation. Yes, Abhiru? Sorry. The literal translation is we command. Mandamus comes to we command. Now, what does this mean? What do we mean by we command? Now, first thing first, please remember, mandamus is only and only for public bodies. That's something that has to do with government, something that is in official capacity. So it can be a government body, it can be a government corporation, it can be a court, it can be a tribunal, but it has to do something with regards to government. And I'll tell you why. So if there is a government officer who is supposed to issue your driving license and has refused to do so, or is to give you passport, everything is okay, you have finished all the formalities, and this government official is not giving you your passport, so basically this person is not doing the official duty that this person is supposed to perform. ठीक है, आपको मना कर दे कि आपको ड्राइविंग लाइसेंस नहीं देंगे, even though this is the legal duty of that person. In that case, court can issue mandamus, the literal translation of which is we command. So basically, we command to you that you do this particular thing because it is your official duty. You have to perform this official duty because we command you. So when is mandamus issued? When the court wants to command a public officer to perform its official duties, then mandamus is issued. Therefore, it is issued against public officials, public body, corporation, inferior court matlab Supreme Court can issue it for High Court can issue it for Session Court, or a tribunal, or the government of India. Super important. Please remember, it cannot be issued against a private individual. So if a private company is not giving you um, uh, the pass to enter a particular place, then you can't get a mandamus issued for it. Definitely, you can file a case in consumer forum, you can go to session court, but it cannot be issued against a private individual. Super important, mandamus. हाँ, so mandamus cannot be issued against a private individual. Super important. इसको गलत करके नहीं आना है. Violation of anything told by the Supreme Court or High Court and you don't follow that will fall under contempt of court. ये मैं आपको already पढ़ा के आई हूँ. So if the court has given you an order and if you're not following it, that is considered as a willful disobedience, then that will be considered as civil contempt. Criminal contempt मैंने आपको बताया था और civil contempt भी बताया था. Anyway, so first thing is it cannot be issued against a private individual. Second and very important thing, if the duty that you're talking about is not a statutory duty, it is just a departmental instruction. Now, ma'am, what is the difference between statutory duty and departmental instruction? See, whenever you are recruited for a government position, you are told your KRAs, you are told your job responsibilities, because that is backed by a law. However, sometimes you can be given certain departmental instructions कि आज ये आपको कर लेना है. This is what you should be doing today. If it is a departmental instruction, my dear students, then for the enforcement of that, mandamus cannot be issued. I repeat, if it is just a departmental instruction, not something that you are bound to do by law, by your KRA, by your job responsibility, then mandamus cannot be issued. Also, if your duty is discretionary, meaning if it is your choice whether you want to do that duty or not, then in that case also mandamus cannot be issued. Let's say you were given 10 lakh rupees as a DM by the government and the government told you to use it as per your discretion. Then I cannot go and say कि मुझे इस 10 लाख में से 1 लाख रुपए नहीं दिए गए. The DM can use it for the construction of roads. The DM can use it for the construction of highways, batteries, laptop batteries low. Just give me a minute. So in that case, the duty will be discretionary. If the duty is discretionary in nature, then in that case, mandamus cannot be issued. Finally, if the duty is that of coming through a contract between two parties. So let's say there was a contract between A and B, and under that a particular job role was given, which was contractual in nature, then in that case also a mandamus cannot be issued. So it can be issued only in job roles that are permanent in nature, not contractual. Finally, you cannot issue it against the President of India. You cannot issue it against the governor, and you can't issue it against the Chief Justice also. Remember, super important. If हाँ, सो मैंडमस का एग्जाम्पल क्या होगा? अभी तो दिया मैंडमस का एग्जाम्पल मैंने आपको. लेट्स से यू गो टू अ पासपोर्ट ऑफिस and it is run by the government, of course, government issuing authority hai. You're done with all your formalities, but your passport is not getting issued. So that is a violation of your liberty, right? So there's a fundamental right involved that you can travel anywhere. You are denied a passport. So you can approach Supreme Court. Supreme Court will issue the writ of mandamus and instruct that officer that we command for you to issue the passport of Priyanka. So understand the applicability of it. My article 21 is being violated. I have the right to, the liberty to travel, and my liberty is being hampered. So knock knock, I went to Supreme Court. Supreme Court said yes, this is a bearing on your fundamental right. I can go and get a writ issued of mandamus. However, let's say it's a departmental instruction. Departmental instruction was SBI ने अपने जो वर्कर्स हैं उनको एक दिन डिपार्टमेंटल इंस्ट्रक्शन भेजा that try and finish giving all pensions by 5 p.m. Now I'll try to do that, but I might not be able to do it by 5 p.m. because it is not obligatory for me to do it. It is just an instruction. So for this I can't go to Supreme Court and say कि departmental instruction में लिखा हुआ था 5 बजे तक पेंशन मिलनी चाहिए पर मुझे 5 बजे तक नहीं मिली, because that is not my statutory duty. It is not my KRA. It is just an instruction that was given to me to make the operation smoother. इन सब पर क्वेश्चन बन सकता है, डिफिकल्ट है, बट यू हैव टू मेमोराइज ऑल ऑफ दिस. एवरी year or so you get a question on these writs. These are low hanging fruits. I'm giving you the conceptual clarity. Make sure you memorize it. Super important. Now there can be, yes, so Amrita is right, there can be instructions on controlling pollution, but for that you can't get a writ issued. So the next one that we talk about is prohibition. Now, my dear students, prohibition and certiorari, these are two writs. One is prohibition, one is certiorari. They're very related to each other, but still different. So again, you might get confused between the two. I'll give you a little hint as to how you can remember it. First thing first, please remember both of these writs are issued by a higher court to a lower court. I repeat, both of these writs are issued by a higher court to a lower court. Now, in prohibition, what happens is, let's say a lower court has taken up a case that is outside its jurisdiction. So, you're aware that High Court has a jurisdiction, Session Court has a jurisdiction. So, they have to work within the jurisdiction that has been given to them. They can't go beyond it. Let's say a court is violating its jurisdiction and going beyond its jurisdiction, and that case is still going on. The case has not ended, but that case has been taken up by the court, and it has been realized by the higher court that the court has gone into a case which is outside its jurisdiction. So it will issue the writ of prohibition, and it will ask the court to stop there and there. Will say that you please stop, you please don't act on this case because it is outside your jurisdiction to do so. However, in certiorari, what will happen, my dear students, is when the case judgment has already come. So in certiorari, what will happen is the court has already given the judgment, and in that judgment, they have gone outside the jurisdiction, or there was some error of law, or it was not in their jurisdiction only to take up their case, but they have already given a judgment. So in that case, what will happen? Higher court will tell lower court that we are squashing your order. The decision that you're giving is cancelled now, and it will not hold any meaning. Understand the difference. In prohibition, the case is going on and you're prohibited to act on it. In certiorari, the case judgment has already come and the order is now squashed, and higher court says that your order has no meaning because there was an error of law, or you exceeded your jurisdiction, or this was not in your jurisdiction only. So how do you remember it? When is certificate issued? After the program is over or while the program is going on? When is certificates issued? Certificate कब issue किए जाते हैं? After a program, right? So what is certiorari? When the decision has come. So whenever you get confused, remember certificate, certiorari. So certiorari is used once the decision has come. Prohibition is issued to stop it there and there. One more important question which can be asked in your prelims. Very important. Prohibition, my dear students, is only preventive. What do you mean by that? It only prevents the lower court from exceeding its jurisdiction. Certiorari, on the other hand, is both preventive and curative. Why? Because it will say कि आपने गलत किया मत करो, and it will bring the case with itself. So in certiorari, court is not only preventing something wrong from happening, but also giving a solution for it. Therefore, prohibition is only preventive, whereas certiorari is both preventive as well as curative. Super important. You will get a question on this. गलती मत करना. किसके अगेंस्ट इशू हो सकती है? जुडिशियल, क्वाज़ी जुडिशियल एंड एडमिनिस्ट्रेटिव अथॉरिटीज. किसके अगेंस्ट नहीं हो सकती? नॉट फॉर प्राइवेट इंडिविजुअल्स. सो फार वी हैव सीन only and only habeas corpus can be issued against private individuals. Mandamus cannot be, prohibition cannot be, and certiorari cannot be. So it cannot be issued against legislative bodies, not even against private individuals or bodies, but it can be issued against judicial, quasi judicial, and administrative authorities. So remember, prohibition again is, and here it will get critical, is not available against administrative authorities, legislative bodies, or private individuals. So only difference that you need to remember is administrative authority permitted for certiorari, not permitted for prohibition. जुडिशियल क्वाज़ी जुडिशियल दोनों में आएगा, प्राइवेट इंडिविजुअल्स दोनों में नहीं आएंगे. नेक्स्ट थिंग दैट यू नीड टू रिमेंबर इज प्रोहिबिशन इज ओनली प्रिवेंटिव, curative is both certiorari is both preventive as well as curative. Just remember certificate, that's how you can remember certiorari. Just for your understanding, इससे ज़्यादा अच्छे से याद रह सकता है. How do you determine? No. So this will again be a case that you'll take to the higher court. That I believe there has been an error. I believe there is a lack of jurisdiction. Or even the Supreme Court can take it up suo moto. So let's say Supreme Court thinks there has been an error of judgment. Then it can be taken up by the Supreme Court as well. For prohibition, only remember that it is for judicial and quasi-judicial body, not against administrative as well. Whereas for certiorari, it is for quasi-judicial, judicial and administrative. दोनों ही private individuals के against नहीं आ सकती और दोनों ही legislative bodies के against भी नहीं आ सकती. The next and the last one is Quo Warranto, which literally means by what warrant. तो अब इसमें क्या होता है? If there is a public individual, there is a public office that has been taken up by an individual which does not deserve to be in that office or is not legally taken up that office. Let's say technically there should have been an exam for it, but someone through the nepotistic tendencies was able to place their son or their daughter on that position without having exams for it. So is that fair? Absolutely not. In that case, writ of quo warranto can be issued, and this person will be asked that you are sitting in this office by what warrant? What authority do you have to sit in this public office? The legality of your public office can be questioned. Yes, suo moto can be issued, right? So, when your legality of a claim is questioned to your public office, which writ will be issued? Quo warranto. क्यों लाई गई है? So that nobody is sitting on public office by illegal methods, by not presenting right proofs, so we have had heard of instances where people have been sitting in public offices without going through the exam procedures. So in that case, your authority will be questioned, and what will be the writ that will be issued? Quo warranto. By what authority? Let's say आप गवर्नमेंट ऑफिसर बन गए, इलीगली अपॉइंट हो गए, तो कोर्ट आपको हटा देगी by issuing this writ of quo warranto. But again, there can be a slight tricky question that can be asked prelims में. हमें गलती नहीं करनी है. What would be that tricky question? This writ of quo warranto can be issued only when that public office is of permanent character. So it cannot be issued for offices which are contractual in nature. My dear students. Sorry, Akash. So please remember, it cannot be issued in case the office is contractual in nature. So ma'am, What if contractual position has been taken up illegally? That means court cannot do anything for it. Of course, court can do, but that would be a normal petition. That can be a normal lawsuit, not a writ under Quo Warranto. For it to be a writ, it has to be either a constitutional office or it has to be a statutory office. That is why it is called substantive public office. Remember, my dear students, what I'm trying to say is not that there cannot be a lawsuit against it. Of course, there can be a lawsuit, but a writ of quo warranto cannot be issued for it. Very important. It can be issued only when the office is of permanent character and it is either a constitutional office or a statutory office. Super important again. Prohibition, certiorari, mandamus, and habeas corpus. Only that person can bring in who has been the aggrieved party. So if I am the one that is impacted, that writ will be issued only when I am seeking the court for it. However, there have been certain relaxations here also with the coming of PIL, which we'll discuss later. But in case of quo warranto, it can be filed by any public spirited citizen. So if I feel this person is sitting on the office illegally, I can go and talk about it. I can go and approach the court for the same. I don't really need to be involved in the matter. It should not be my personal stake. Anybody who is interested can go and approach the court for the issuance of the writ of quo warranto, which says by what warrant or under what authority. Don't make a mistake. Again, you can be asked a question on it. हाँ, इलीगल कैसे भी बैठ सकते हो यार. इलीगल बैठना कैसे कैसे एग्जाम्पल दूँ आपको. फॉर एग्जाम्पल, how so lateral entry is through a lawful procedure. There were there would be interviews conducted, your papers would be checked, your claims would be addressed. But let's say somebody was never taken through an exam, there was never an interview. We have often seen है, तुम लोग ने शायद ऐसा कुछ सुना नहीं है, हमारे यहाँ तो बहुत होता है. They often in schools you'll see in rural areas, a person would be working in that school for 5 years and 5 years later ये पता चलता है कि वो तो बिना एग्जाम के उसमें टीचर लग गए थे. क्या आकाश, क्या एग्जाम्पल दिया है तुमने? हाँ, सो गुरसिमरन इज राइट. इट ऑफन हैपेंस इन केस ऑफ, नहीं मैं नाम नहीं ले सकती. हाँ हाँ, सो वेस्ट बंगाल में ब्यूटी सेइंग बहुत होता है. सो इट इज अ वेरी कॉमन प्रैक्टिस. आई डोंट नो यू आर लिविंग अंडर द रॉक और व्हाट. पता नहीं तुम लोग को क्यों नहीं पता है. मतलब इट्स अ वेरी कॉमन प्रैक्टिस. बहुत ज्यादा होता है ये. हमारे यहाँ तो राजस्थान में तो आई हैव हर्ड अ लॉट. सो यू पीपल मे बी कम फ्रॉम बेटर प्लेसेस. आई एम हैप्पी टू नो दैट. So, so basically, people would occupy a government position whereby you don't really passed it through an exam and you get a salary. In fact, there have been cases where people have been sitting in government positions after their retirement. Even that will be a case of quo warranto because you don't have the legal claim to sit in that office after 60 years.